So to begin with, as an introduction, I would just like to give you an overlay of what I propose to speak about over the next 20 to 30 minutes. And as Forum mentioned, we can take questions at the very end of the session when both Jonathan and I have spoken. So as an introduction to my presentation, what I hope to cover is firstly why Ireland is a fund domicile, and to give some qualitative and quantitative analysis around that for your benefit. I'll also talk about Ireland as an international hub for fund administration, as a lot of international funds, not just Irish domicile funds, but international funds are administered from Ireland. I'll also focus on specifically Irish domicile funds and asset types and how they've performed over the last year. Then I will get into more granular detail in relation to the legal structures that are available in Ireland for regulated funds. Give and talk around some of the organizational structures for some of those funds, talk about the regulatory framework for UCITS and AIFs, which are the two categories of regulated funds that are possible in Ireland. I will talk about the tax advantages of establishing a fund in Ireland. And I will finish by, I suppose, chatting through, what is involved in the establishment process from the beginning to the end stage, and the various phases involved, what's involved in those phases, and time frame. Hopefully the presentation won't take more than 20-25 minutes max, and then I'll turn over to Jonathan and Cayman. So turning to the next slide. Why Ireland is a fund domicile. Well, to begin with, it is an internationally recognized jurisdiction with membership of the European Union, member of the Eurozone. So the Eurozone are those countries within the European Union that have the euro as their primary currency. So currently there are 19 of the 27 EU member states that are members of the Eurozone, and Ireland is one of those. Ireland is a member of the OECD, the Organization for Economic and Cooperation Development. It's a member of Financial Action Task Force. It's a member of IOSCO. And sorry, so member of IOSCO, and it's also as I mentioned, it's a member of the EU, providing full market access to the EU. So one of the key points there is that once you're established or incorporated in, for example, one of those EU member states like Ireland, then you can essentially provide services cross-border within the EU. So it's English speaking, and similar to India, it's a common law jurisdiction. Ireland has a highly educated and skilled workforce. It has a tax efficient regime compliant with OECD guidelines, and we'll talk a bit more about that tax regime later. Ireland has an extensive tax treaty network with over 70 countries worldwide, and it has a regulatory regime open and transparent and focused on investor protection. So just on that point, the Central Bank of Ireland is the competent authority in Ireland that is responsible for the stability of the financial markets and for the regulation of financial institutions and investment firms and investment funds that are domiciled in Ireland. And it's also responsible for the protection of consumers and investors in Irish domicile funds. So the remit of the Central Bank of Ireland is quite broad. In the context of investment funds, I suppose how they ensure efficient and proper regulation of those funds is through a number of processes. Firstly, a rigorous authorization process in the establishment and authorization of those funds. Secondly, through ongoing monitoring to ensure that those funds are complying with prudential requirements, and they also have a fitness and probity regime under which they approve certain persons proposed to be appointed to control functions in accordance with that regime. So I suppose the supervision model of the central bank is a risk-based approach. So they tend to give more focus and more structured engagement on those firms that are more likely to have an impact on the stability of the financial system and on consumers and investors. And with the intention being to, through that structured periodic engagement, to perhaps avoid and mitigate any risk that may be identified for those particular firms. For those firms that are less likely to result in a or to impact on the stability of the financial system and impact on consumers and investors, the central bank has a reactive supervisory model where they supervise these entities through more teamed inspections rather than periodic engagement, one-to-one engagement. So Ireland I suppose has 250 of the world's leading financial services firms based here, including half the top 50 banks, and that each of these have international presence in Ireland. So the financial services centres established here in Ireland in 1988. So Ireland has over 30 years of experience as a leading fund centre. Ireland has innovative fund products catering from your traditional long only to your very complex alternative strategies, and more recently even a focus on real assets. And it's a leading centre for the servicing of hedge funds, with 40% of global hedge fund assets serviced in Ireland. So as I mentioned earlier, Ireland is a base as an international hub from which administration services are provided, and that's the basis for why they have such a presence within the global international market in terms of servicing from an administration perspective. It's also Ireland's also a leading European domicile for ETFs, with over 65% of total assets of European ETF market being managed in Irish domiciled ETFs. And finally, Ireland is a hub for cross-border distribution, with Irish funds sold in over 90 countries worldwide, across Europe, the Americas, Asia, the Pacific, and the Middle East and Africa. So on the next slide, you'll see from this chart that it includes quantitative, I suppose, facts as of December 2020, supporting why Ireland is an international fund jurisdiction. The slide gives a good snapshot of the Irish funds ecosystem as of December 2020, highlighting, among other things, the number of fund promoters involved, Irish parties involved, a number of employees involved servicing the industry, and the number of countries to which Irish funds are distributed. So you can see from the very top row there that there are over 566 promoters of Irish domiciled funds. So these are international asset managers that have chosen to set up in Ireland, and they would have one of a number of Irish legal schemes in Ireland and a multiple of sub-funds in those schemes. And when one looks at the number of funds that are serviced from Ireland, those number of promoters almost doubles to 1,027. So these are promoters of international as well as Irish domiciled funds administered from Ireland. So as of December 2020, you can see from the right-hand side, there was 3.3 trillion in assets under management in Irish domiciled funds. And if you go to the left-hand side, you'll see there's over 5.4 trillion in assets under administration being serviced from Ireland. Again, that's both Irish domiciled and non-Irish domiciled funds. From the center row, you can see there's over 16,000 people employed in Ireland that are servicing the funds industry, right across from being employed within the administrators and depositories that are operating here in Ireland on the ground, from the legal advisors, the auditors, your asset managers that are based here in Ireland, and also specialist service providers, which would be your fund your fund management companies. It could be professional valuation companies, consultants, and the list goes on. So as already mentioned, Irish funds are sold to over 90 countries, and total number of funds based on this, at the very end row, you'll see close to 14,500 Irish funds, with the split there between Irish domiciled and non-domiciled on the right-hand side. So moving to the next slide, So this focuses on the administration of the funds, and as I mentioned, specifically on both Irish domiciled and the non-domiciled funds. And you'll see from this side that it gives a snapshot of the total assets under administration in Ireland relating to Irish funds as against assets under administration in Ireland relating to non-Irish domiciled funds. So as of 30 June 2021, there were 6.28 trillion in fund assets administered from Ireland, with just over 58% of those fund assets representing Irish domiciled funds and 41.46% of those fund assets representing non-Irish domiciled funds. So the split in favor of Irish domiciled funds just slightly higher. The next slide gives you, I think, focuses more on the number of funds as opposed to the assets under management of those funds. So as you will see from the slide, as of 31 July, as of 30 June 2021, there were 15,121 funds administered from Ireland, with just over 53% in number representing Irish domiciled funds, and just over 6% in number representing non-Irish domiciled funds. So turning to the next slide. This slide focuses specifically on Irish registered funds. So these are only Irish domiciled funds. And it gives a breakdown of net assets in Irish domiciled funds that are Irish UCITS and Irish AIFs. So these are the two categories of regulated fund structures in Ireland, your UCITS and your non-UCITS, which we refer to as alternative investment funds or AIFs. It also gives a number of funds represented by each type of fund. So as you will see from the slide, as of 31 July 2021, there were 3.74 trillion of net assets under management in Irish domiciled funds, represented by 8,273 funds. In relation to the breakdown of those funds into Irish UCITS and Irish AIFs, you will notice from the left column that there were 2.84 trillion in net assets under management in Irish UCITS funds, and there was about 899 billion of assets under management in Irish AIFs. So the split percentage-wise in terms of assets is probably around 76% in UCITS and 24% in Irish AIFs. So turning to the next slide, this gives a breakdown of the fund asset types. As mentioned earlier, the NAV of Irish resident funds or domicile funds reached an all-time high in July, reaching over 3.74 trillion in assets, and that's euros, as I said, as of the end of July 2021. This slide gives you a snapshot of the asset fund or asset type performance over 5 quarters up to the 30th of June 2021. And you will note all fund types except money market funds increased their NAV during the second quarter 2021. In that quarter, total NAV increased by 5%, and this increase was split between 48% net investor inflows and 52% of valuation gains. So, as you will note from the slide, equity funds showed the largest increase in the second quarter of 2021, up 8.2% to over 1.2 trillion euros. And money market funds decreased slightly by 0.2% in that quarter, while other fund types increased between 3% and 7%. So I'm turning now to the legal structures. I spoke very briefly about the regulatory fund structures being either a UCITS or an AIF, and I'll speak a little bit more in detail about those later on. But firstly, I want to just deal with what are the legal structures. So I suppose when an asset manager decides, well, they want to establish a UCITS or they want to establish an AIF, the question is, well, what legal structure are they going to utilize? And on that basis, well, what legal structures are available in Ireland? So there are 2 corporate structures available in Ireland, which are the first 2 highlighted in that chart. So you can see there's the ICAV which is an Irish collective asset management vehicle, and there's the investment company. So from the very beginning of the International Financial Services Centre here in Ireland, funds were able to be established as companies, or public limited companies that could be, sold, shares could be sold to the public. In 2015, a more specialized corporate structure was established for investment funds called the ICAV, as I mentioned, the Irish Collective Asset Management Vehicle. And the idea was to make it more specific or tailored to investment funds, as opposed to the older company structure, which was specifically tailored for all types of companies, not just investment companies, but also trading companies. So the idea was to make it more efficient. So since 2015, that structure has been available. And like the investment company, it's very similar. It's a corporate structure, so investors receive shares in the company or in the corporate structure. They have no rights other than what's set out in the constitutional document. They have no interest in the assets of the fund. So it's very similar to what you and I would expect of a corporate structure. The third legal structure in the chart is a unit trust structure. And a unit trust structure is a structure that's constituted by a deed being entered into by a management company and a trustee. The unit holders, unlike I suppose a corporate structure, the unit holders in a unit trust have a beneficial interest, an undivided beneficial interest in the assets of the trust. But that really doesn't make much of an operational or a practical difference in terms of the investors and the value of the shares and just the general holding of units in the unit trust vis-a-vis shares in a corporate. What I would say is that the unit trust structure is probably more utilized where a particular jurisdiction is familiar with that structure, and therefore the preference of the promoter or asset manager might be to establish a unit trust in order to facilitate unit holders in that jurisdiction. There may be also a regulatory reason why a unit trust is required. Turning to the CCF and the ILP, which are the latter two of the legal structures available. So the CCF is a common contractual fund. So it's a contractual type of fund that's constituted by a deed, again, entered into by a manager and a depository. It's mainly used by institutions who want a tax transparent structure. So it's very popular with pension schemes who want to use it as I suppose, as a pan-European structure in order to achieve economies of scale. The ILP is a structure you'll all be familiar with, obviously, because it's quite prevalent in India. It's your investment limited partnership. So, and again, that has got a recent boost here in Ireland because of the, I suppose, updated legislation to bring it into the 21st century in terms of what I suppose asset managers, promoters expect in terms of ILP structures in order to facilitate investment in real assets. So that has very much come to the fore more recently. So, but overall, those five structures, the predominant structure probably is your ICAV corporate structure. Very rarely will you see a unit trust structure, as I said. CCFs probably only in the context of pension schemes, and the ILP probably more so now in terms of asset managers focusing on private equity or investment in real assets where they're looking for a closed-ended structure, and investors are used to this ILP structure. So that's just a general overview of the types of legal structures in Ireland. You can see from the chart that the first four are only available to UCITS, whereas the ILP is an additional legal structure that's available to AIFs. So moving on to the next slide, you can see there's an organizational chart there. Now, it applies only, this is a chart that I've set up just to give you a flavor of a corporate legal structure, fund legal structure. So this would apply in respect of, for example, the ICAV, or would apply in respect of a company. So you can see there's a board of directors of the UCITS corporate, or if it's an AIF corporate fund, and there's an appointment of a UCITS management company if it's a UCITS, or alternative investment fund manager, or AIF if it's an AIF. And you will see that particular entity, that fund management company entity, then makes the appointments in respect of the performance of the administration function. And it's generally an Irish administrator here in Ireland who would perform the administration of the fund. And that would include your fund accounting, your valuation, your transfer agency and register services. It would be, again, the management company would appoint the distributor. Now, the distributor could be anywhere worldwide. You don't necessarily have to appoint a distributor, but if you did choose to appoint a distributor to market in particular countries, it would be an appointment made by the management company. And you can also see there that it's the management company also appoints the investment manager, and that could be an investment manager based worldwide. Has to be approved by the central bank in order to act as investment managers. So there's certain jurisdictions where the central bank will automatically facilitate an application being made, India being one of them. But there's still a process to go through to have that investment manager cleared by the central bank before the fund will be authorized. So separately, you'll see that there's a depository to safekeep the assets of the fund, and that appointment is generally made by the UCITS itself, as opposed to the fund management company. And you'll see also at the fund level, you'll see, in addition to the directors, at that, of the board of the fund, corporate fund, there's also a secretary or corporate secretary appointed, which constitutes an additional officer of the corporate. There's a money laundering reporting officer appointed, and there's your auditors and legal advisors appointed. So hopefully that gives you a sense of the organizational structure, at least for a corporate structure. Turning to, I suppose, the UCITS specifically. So I think we talked about, I suppose we talked about the legal structures, and so the purpose of this slide is to focus now specifically on the first of the two regulatory structures, which is the UCITS. So UCITS are collective investment schemes established and authorized under a harmonized EU legal framework, under which a UCITS established and authorized in one EU member state can be sold cross-border in other EU member states. So if it was established and authorized in Ireland, it can be sold cross-border throughout the remaining 26 EU countries. So this is referred to, and you may have heard it as referred to as the UCITS passport. And as I mentioned, since the financial services was introduced in 1988, UCITS have become the gold standard EU investment fund, almost comparable to the US 1940 fund. And the UCITS is recognized not only in Europe, but as mentioned earlier, also further afield, with many of the non-European jurisdictions accepting UCITS as suitable products for retail sale into their domestic markets. And I mentioned earlier, North America, Asia, for example, South America, Middle East, just to give you a flavor. Now, UCITS are open-ended with redemptions at least twice a month. However, most UCITS have, I suppose, redemption frequency probably daily, so maybe daily liquidity. But occasionally you could have them maybe once every week, as opposed to the threshold of once every 2 weeks, which would accommodate your at least twice a month. In relation to permitted asset classes, the UCITS have evolved over time in that UCITS can now invest in your transferable securities and your money market instruments, deposits, collective investment schemes, and derivatives. So you have a full array of asset classes that you can invest in through UCITS. The key points, however, for the UCITS structure is that the investment and borrowing restrictions. So the requirements are that the investment requirements that you invest on a diversified basis. So what's known as the 5-10-40 rule. So you're limited to no more than investing no more than 5% of your NAV, of the fund's NAV, in any one issuer. But you may increase that from 5% up to 10% with an aggregate of 40% being adhered to. So it's quite restrictive in terms of your exposure that you can get to each of those issuers. And in addition to borrowing, there's a 10% temporary borrowing limit. So again, borrowing limit is quite low. And also there are, in terms of derivatives and the usage of derivatives, there are very strict rules around what level of exposure you can be obtained. So turning to the next category of fund, which is the AIF. I'm just going to focus, there's two categories of AIFs, a retail AIF and those that are sold to qualifying investor AIFs, are sold to qualifying investors, and they are called qualifying investor AIFs, or QAIFs as an abbreviated term. And the important thing to note about qualifying investor funds is that the investor must be, fall into one of three categories. It needs to be a professional investor, as defined under EU MiFID rules here in Europe, or it must be an informed investor, one that is, that's willing to certify that is aware of the risks, or alternatively, it must be one that has been appraised or certified as having appropriate expertise and experience by an EU credit institution or an EU investment firm. So the other key point about a qualifying investor fund is that there's a minimum subscription of 100,000. And while there are some exemptions, generally that 100,000 must be adhered to by all qualifying investors. So the benefits of the QAIF are that, unlike a UCITS, which is highly regulated and supervised by the central bank, while the QAIF structure is regulated, the central bank generally does not impose any borrowing or leverage requirements or investment requirements. The exceptions probably are more in relation to loan origination type funds. There are a few exceptions, but the general rule is that the central bank doesn't impose. The benefit of it is speed to market, so you don't actually have to submit documents for review or approval by the central bank. Another advantage is that it can be sold cross-border, just like UCITS. It can be sold cross-border throughout the EU, but only to professional investors. And so again, the passport is applicable here as well, but as I said, only to professional investors. Can't be sold using the passport to retail investors in Europe. So the key point, last point I just want to raise about QAIFs is that the investment strategy used can be quite broad. It can invest in your traditional type assets. It can be used to invest in alternatives, to real assets, such as, into private equity, private debt. And obviously I suppose the liquidity of the underlying assets would determine to what extent it is, to what extent it is open-ended with limited liquidity, or closed-ended in the context of redemption frequencies. So turning to tax and the advantages of Irish domicile funds. So in reality, from a direct tax perspective, there's no tax on income or gains at the fund level. There's no tax on the fund's net asset value, unlike some other of our competitors. There's no withholding taxes on payments out to non-Irish resident investors, except in respect of real estate funds, or funds that hold interests in real estate. In relation to indirect taxes like VAT and stamp duty, there's no stamp duty or transfer taxes on the issue, purchase, or disposal of shares in the fund, and there's no VAT and the material services provided to the fund. And then finally, as mentioned earlier, Ireland has over 70 double taxation treaties, with countries worldwide. And even if a particular double taxation treaty cannot be availed of, it's always possible to put a tax efficient vehicle underneath the Irish fund structure as a subsidiary in order to maybe perhaps avail of that double taxation treaty agreement. So finally, this is my final slide. I just thought this slide would be helpful in giving you a sense of what is involved from start to finish with an Irish fund structure. So this caters for both UCITS and AIFs. You can see there's a number of phases to it when you look at the various columns. So the very first column is really the design phase, or the definition phase, where, in terms of, you have to choose, well, whether it's a UCITS or an AIF, you have to choose what legal structure, you have to choose, if it's a corporate structure, your board of directors, there needs to be 2 Irish resident directors on that board. You need to select your administrator, your depository, the fund management company. So there's a lot of selection process there in order to kickstart the drafting phase, which is the next phase. And And indeed, as you can see further down, if this is a UCITS, the prospectus must be reviewed by the central bank. And in order to facilitate that, the investment manager application must be made for them to be cleared in order for them to be approved to act as investment manager of Irish collective investment schemes. So once the central bank approves the investment manager, the prospectus application can be made if it's a UCITS. If it's an AIF, particularly a QAIF, there's no submission to the central bank. The prospectus, you just carry on with the phases. An important, I suppose, phase from an operational fund admin and investment manager perspective is the third phase there in the middle of the chart, which talks about more the due diligence around the fund accounting and other services, the risk investment compliance, custody account opening and security accounts. So all that operational element that needs to be dealt with during the time frame from the start to the finish of the fund. So the final steps are essentially then which are where the documents have all been approved and cleared, is the board actually approving those documents, executing them, making a formal application to the central bank. And finally, you have, if it's, for example, being sold in India, you might have your FPI application, or making investments in India, rather, you'd have an FPI application. If you're an Indian investment manager, you might have a Section 9A application under the Income Tax Act in India. And of course, once the fund is authorized, if you want to, and presumably you would want to do that, you can make an application to register the fund for sale in the various European jurisdictions using the passport. So that concludes my presentation, and I'm just conscious that I've ran over just a small bit, so I'm just going to quickly leave it there, and thank you all for listening, and ask Jonathan to take over at this point. So,
hello.
So Jonathan, I think you're on mute.
Yeah, hello. Mr. Kelly?
Yes, I can hear you, Forum.
Yeah, so there are a few questions. So should we take it at the end, or you may want to respond to it?
Yes, I'm happy to take any questions, but perhaps I could take the questions, and maybe in the background we can liaise with Jonathan, who may be having some issues joining. I know I can see his name, but he doesn't seem to be any interaction there.
Yeah, I think he can. There is an option to unmute. So should I unmute and then he can talk?
Please, yeah.
Mr. Law, can you check now? Mr. Law, can you rejoin? I think there is some issue at his end.
So Forum, if you wish, while we're waiting Jonathan to join us, just texted him. But while you're waiting, I'm happy to take some of the questions.
Yes, sure. Okay. So Mr. Binesh Balan wants to ask something. So I'm just, Mr. Binesh Balan, can you unmute and ask your question?
Yeah, so I can see the first question for him is whom to contact for the fund details and process. So for the fund details and process, please share the relevant desk details. So I guess just in terms of because there's just in terms of I guess that very last slide, which talked about that design phase. So so I guess if anyone has I suppose an interest in Ireland as a domicile, particularly where we find ourselves is that where I suppose where asset managers they want to access the European market. I mean, that's the main reason why we see asset managers want to establish in Ireland. And consequently, when they're looking at an Irish structure, then as part of that design phase there's introductions and contacts to be made. So, I mean, we're happy to facilitate if anyone has any interest in the Irish domicile. I'm happy to facilitate making introductions, giving the administrators, depositories, the fund managers operating in the domicile, and assisting, I suppose, the asset managers in making those contacts and selections. So once the selections are made, you'd have seen from that last slide that the next phase is drafting of contracts. So generally speaking, most of the service providers will have their own templates. So I think Jonathan is just unmuted there, so maybe he's back.
Yes. Yes.
I am back. Yes, thank you for your patience. I had some technical issue there. My system closed down completely, so I had to rejoin the meeting. So I'm sorry for the delay. I've also got no video at the moment, so I do apologize for the technical issues.
Yeah, no problem.
So I might be able to share your slides, Jonathan.
Yeah, can I send those to you, Brian? Are you able to do that? I'm sorry for it was working fine until the last 10 minutes. I'll send them to you.
Actually, I might have them from Jamie Ann, so I will share these for you.
We have them. Good. I'm sorry, we have been having some technical issues here of late, so I do pass on my apologies. If you're able to share those slides, Brian, that would be very helpful, please.
Now, can you see those, John?
Yes, the slides are visible.
Maybe Brian, you're able to control those slides as I narrate my text and I just mention next slide. Could you advance?
Yes, of course.
Without any further delay, again, my name is John. Discussing some of the general aspects of setting up and launching a fund structure in Cayman. That's really set out.
Jonathan?
Hello?
Yeah, the line is not good.
Hello?
I think we're all having difficulty hearing you.
Oh, okay. Is that
No, it's.
Are you still there? Can you hear me?
Yeah, it's intermittent. Maybe if I mute, maybe that would help. Maybe if I mute, 1 second.
Okay. Is that, can you hear me better, Brian? Can you nod your head or thumbs up or thumbs down. Is that an improvement?
That's a bit of an improvement, Jonathan. Yes.
Okay, I'll see you. So slide 1 and slide 2 I've covered in terms of what I'm planning to sort of talk about today. At slide 3, by way of background, information on Cayman. Part of the island's success is that Cayman has fully embraced each of the international legislative initiatives of various onshore governmental and quasi-governmental agencies, beginning with FATCA through CRS, FATF inspections, and most recently in relation to the BEPS initiative, so-called local substance requirements. Next slide. Just for those of you who are the Caribbean, I can see the 3 islands that make up the Cayman Islands, located to the west of Jamaica and south of Cuba. So moving on to the next slide, Cayman has become one of the leading international domiciles for funds, offering a variety of fund structures with differing levels of subscription requirements, service provider requirements, and authorization.
I think there is some disturbance again.
I was cut out again. I think I'm now back. Can you hear me, Brian? Can you nod? Yeah. Okay. Continue. Slides. Sorry, I have got to okay, sorry, I'll just continue my text. There are no restrictions in Cayman imposed in terms of investment objectives or strategy, with Cayman funds being suitable for a whole host of different strategies, from directional equity, equity arbitrage, global macro, fixed income, arbitrage, and of course cryptocurrency, which is very popular in Ireland. The primary reason for Cayman's popularity is its tax-neutral platform for investment structures. A Cayman fund will generally not be liable for any direct or withholding taxes in Cayman, and therefore it will not add a tax layer to any taxation imposed in the jurisdictions where it holds its investments or where its investors are located. Cayman has a common law legal system which is based on the internationally recognized standard of English law. Cayman makes use of specialized commercial court judges and has the Privy Council as its final appellate court. Cayman has a regulatory framework including anti-money laundering, counter-terrorism, and information exchange regimes which meet or exceed international standards. Cayman has a proven track record of a successful fund industry, and Cayman currently stands as one of the largest financial centers in the world. Cayman has many well-established and respected household names in its service providers, many of whom have been operating in Cayman for decades. Investors and managers are, of course, very confident and familiar with, and in many cases prefer dealing with Cayman fund structures. Cayman has a stable political and economic environment, with its legal framework being based on the English system, as I mentioned, defence matters being in the hands of the English government, and with the oversight of a governor who is the representative of the British Crown. So moving on to the next slide, fund vehicles. Why use the single exempted company structure? Well, firstly, the single company structure is very simple to establish, simple to operate, and less expensive than more complex structures. The single company structure offers a plug and play option for managers who simply want a quick and cost-effective way to get their fund to market. And given its widespread usage, the Cayman Islands exempted company structure, whether used as a standalone or as part of a master feeder structure, is familiar to most, if not all, service providers, investors, and their advisors. The choice of legal structure for a fund will usually depend on a number of issues, including investor familiarity, investor capacity to invest, borrowing and leverage proposals, and operational flexibility. The constitutive document for a Cayman Islands company is its memorandum and articles of association. And ultimate management authority resides with a board of directors, 2 of whom must be appointed, but neither of which need to be resident in the Cayman Islands. Cayman Islands companies issue shares to investors, and those shares can be issued as voting and/or non-voting shares. Where appropriate, the company might issue non-voting shares to its investors and issue voting shares only to its investment manager in order to retain operational flexibility to make non-material amendments to the fund structure and its documents. Why use an SPC or segregated portfolio company? Well, the SPC is also a company and thus a corporate vehicle with its own legal personality. An SPC is typically is permitted to create one or more segregated portfolios in order to segregate the assets and liabilities of the SPC held within or on behalf of a portfolio from the assets of other portfolios. There will not be a board of directors at the segregated portfolio level because it is not a separate corporate entity. Usually, the board of directors of the SPC in a fund structure will delegate management of the SPC and its portfolios to the investment manager. The SPC can facilitate different investment managers to be appointed to manage different portfolios. Typically, the other service providers, such as administrator, custodian, and broker, will come attached to the SPC at the vehicle level. Therefore, these can be presented as a package to managers who simply want a simple structuring solution. The SPC platform is as popular as a plug-and-play option for managers and investors who simply want a quick and cost-effective way to get their fund to market. Launching a segregated portfolio on an already established platform is far quicker and cheaper than setting up a new fund from scratch. Limited partnerships, why use them? Well, limited partnerships are typically used by managers establishing private equity or venture capital funds. The flexibility of partnership accounting, together with the very practical operating provisions of the Exempted Limited Partnership Act, make the limited partnership model very attractive to these types of funds and the way in which they function. And finally, a note on unit trusts. The key attraction of the unit trust model is the involvement of the trustee. Typically, a large, highly regulated bank or other respective financial institution who acts to oversee the operation of the trust is under a fiduciary duty to the unit holders. This aspect alone of the trust brings a great deal of comfort to investors who are nervous about the operations of the fund, particularly if the investment strategy is highly complex. On to talk about mutual funds. I think that's on slide number 10. The Cayman Islands Monetary Authority, or CIMA, often referred to as CIMA, is the competent authority responsible for the initial authorization and ongoing supervision
sorry to interrupt.
Sorry to
interrupt. Mr. Kelly, the slides are not visible.
Okay, slides are not visible. Okay. Can you see that for him?
Yes.
Apologies. Sorry, Jonathan, go ahead.
Yeah. Heightened interest in the operation of these. Second category, registered funds, the most common type of fund in Cayman, with a mandatory minimum subscription of $100,000 US. Next, administered funds, with no investment minimum, but the requirement to employ the services of a Cayman Islands-based fund administrator. Limited investor funds, a fund with 15 or fewer persons who have the power to control the governance structure of the fund, or be regulated by CIMA, but certain amendments made to our Mutual Funds Act last year now mean that these funds are required to register and be regulated by CIMA. And there was a deadline set somewhat distant now of August of last year for all funds in this category to register. Master funds, well, they operate in a master feeder structure and they can involve any one of the above type of funds. So, next slide, private funds. The Private Funds Act brought historically unregulated fund structures under the supervision of CIMA, typically without liquidity for investors or so-called closed-ended acts, and were thus unregulated. The Private Funds Act now requires that closed-ended structures are registered with and are regulated by CIMA. In addition, the new law sets out specific requirements related to how the fund must keep its records, how often the fund is to value its assets, and the methodology to be used, the use of a custodian to safeguard assets of the fund, the manner in which the fund must perform cash monitoring, and how the fund is to keep records of its securities trading activities. Moving on to some operational requirements. Cayman Mutual, this is slide number 12. A Cayman mutual fund must issue an offering document unless CIMA exempts the fund from this requirement, which is rare. The offering document must describe the equity interests of the fund in all material respects and contain such other information as is necessary to enable a prospective investor in the fund to make an informed decision as to whether or not to subscribe for or purchase the equity interests. Any material change affecting the terms of the offering document of a mutual fund during any period when there is a continuing offering of equity interests must be Cayman private funds are not required to issue an offering document where the terms and conditions of the fund set out in its limited partnership agreement are adequately described. But generally, most promoters will want to issue an offering document as it's a clear statement of the offering terms, and investors, frankly, will expect to receive one. The style and content of offering documents and other marketing materials varies greatly from fund to fund, and as a result, CIMA has issued a list of minimum disclosure requirements for the marketing materials issued by both mutual funds and private funds. Operators. There is no requirement for a Cayman domiciled corporate fund to appoint Cayman resident directors, although tax advice provided to the fund or its promoters may be that the appointment of Cayman resident directors may be beneficial. There is no requirement for a Cayman domiciled limited partnership fund to appoint a Cayman general partner, although again, the tax advice may be that would be beneficial. Where a corporate general partner is used, which is typical, this can be a Cayman company or a non-Cayman company. The non-Cayman company would have to be registered as a foreign company under our Companies Act. A Cayman fund structured under a Cayman law-governed unit trust instrument will generally have a Cayman domicile trustee, which needs to be licensed under our Banks and Trust Companies Act. There is no requirement for a Cayman fund to appoint a Cayman-based investment manager or investment advisor. However, where a Cayman entity is considered appropriate for these roles in terms of tax structuring, for their shareholders, or in terms of regulatory efficiency, the manager or advisor will either be licensed under the Securities Investment Business Act or will fall within an exemption under that law. Cayman entities acting as investment managers of funds need also to be aware that there are local substance requirements which will need to be met. The administrator, well, except for the administered fund, there is no requirement for a Cayman domiciled fund to appoint a Cayman-based administrator. In addition to the usual suite of middle and back office services, for most funds, the administrator will generally perform the anti-money laundering services and tax reporting. The role of the administrator, in my own opinion, is of increasing importance, given the scope and extent of services that these institutions can provide. When launching a fund, the selection of the administrator that best fits the need of the fund and its promoters is a decision of crucial importance and will not always come down to fees. The administrator may also be the gateway to launching a new fund on its own SPC platform, as I noted before. Mutual funds and private funds are required to appoint an auditor, and that auditor needs to have been approved by CIMA. The accounts of mutual funds and private funds must be prepared and their audit carried out in accordance with IFRS standards or US, Japanese, Swiss GAAPs, and certain other GAAP standards, which will be approved by CIMA in due course. The custodian in PB, well, there's again no requirement for a Cayman fund to appoint a custodian or a broker. And if they are appointed, there is no requirement for them to be domiciled in Cayman. Cayman private funds must ensure, however, that the fund's assets are held in segregated custody accounts. Subject to certain conditions, a private fund may not need to appoint a custodian where it has notified CIMA that given the nature of the fund's investments, it's neither practical nor proportionate to do that. A Cayman domiciled company and a Cayman limited partnership are required, however, to maintain a registered office in Cayman. A general partner to a Cayman law governed limited partnership, which is registered as a foreign company under the Companies Act, is required to appoint an agent for the service of process in Cayman. Just a few words about anti-money laundering. Because of the expansive scope and complexity of this area, funds will typically engage the administrator or other specialist services provider to supply the necessary services to ensure the fund complies with its AML and countering of financing of terrorism obligations. These obligations include the appointment of a compliance officer, an anti-money laundering reporting officer, and a deputy. The fund operator should bear in mind that despite engaging third parties to provide these services, it is still the fund who remains responsible for complying with its legal obligations. And thus the appointment of any service providers to provide AML services needs to be carefully assessed and regularly monitored. Just a couple of words about data protection now. Generally, a fund will be considered a data controller for the purposes of the Data Protection Act in Cayman Islands. In addition, the fund's administrator and possibly some other service providers will be treated as data processors. The fund should be aware of its obligations to its investors as regards the use of their personal data. The fund should include disclosures in its offering memorandum and subscription agreements, and should also ensure that the relevant services agreements where the counterparty falls to be treated as a data processor, so for example, the administration agreement, contains relevant restrictions on the processing of data and any transfer of it. A few words on timing. For most funds, the timing for launch is rarely driven by Cayman Islands legal issues. The island prides itself on the speed to market features of its funds regime. Typically, the launch of a fund will be determined by the time it takes to settle the terms of the fund's offering and constitutional documents and the terms of its various service provider agreements. The CIMA registration process is paperless and efficient. Generally, a fund will be registered by CIMA within 3 to 5 business days. Licensed funds, those are the retail type of funds, they will take a little longer, frankly. Private funds are permitted to engage in discussions with and even agree subscriptions from investors prior to being registered with CIMA, but they cannot accept capital contributions until they are so registered. Folks, I'm just aware of the time. I think I've gone over by a couple of minutes. I had some extra details, but it's not particularly material. So I think I'll just end there, if that's okay.
So Forum, I think maybe, I'm not sure if we have time, but should we at this point perhaps turn to to some questions, do you think? Or alternatively, if time is an issue, perhaps some of the participants could reach out directly to us and we're more than happy to answer those any questions they have. In addition to that, I might emphasize that Jonathan and I will share our presentations with you, and maybe you can circulate them to the wall,
Yes.
the broader listeners today. So please advise how you want us to proceed.
So I think we can take a few questions, and then if they want to reach out, we can help them out with your and Mr. Jonathan Law's email ID, and they can send the queries over there.
Of course. So so maybe just in terms of the questions, I think we'd started before Jonathan joined. So So
Yes.
I suppose, so we talked about the contacts and fund details, and similar to me, if there's any queries in relation to Cayman, please feel reach out to Jonathan. So when you receive our slides, our name and contact details would be at the last page of those slides. So you can see Jonathan's slides for the minute are available there, and his details are at the back of those slides. And similarly, mine are at the back of the slides that will be forwarded. So in relation to so there's the next question, what is the cost of funds set up and operational cost? So very much varies depending on the type of structure you're setting up. But if ultimately you're talking about you know, and which is the case with a lot of the Indian funds that have been established to date, where they're focusing either on equity or debt or a balanced type fund, well then, you know, we're probably talking about, you know, because therefore you're not talking about any, you know, you're talking about type of vanilla type structures, you know, generally you should be able to establish it, you know, taking into account legal and service provider initial setup costs of anything between, I would say, between 40 to 50,000. That's euros. So, and then in terms of operational costs on an ongoing basis, we're probably talking about, I'd say, anything between about between 150 and 200,000 euros. But generally speaking, what we see is that there might be a threshold of 1.7, you know, percent type of TRs, try to ensure costs are below that of the net asset value of the fund. But that's just a very preliminary indication. But generally, as I said, please feel free to out to me or Jonathan, and we can give you a little bit more color depending on the type of strategy. So who are the eligible custodians in India for you to set up? Well, so the depository is Irish based, but they will have a custody sub-custodial arrangement to their custodial network with a local Indian sub-custodian. So you know, and there are lots of the, you know, the depository sub-custodians that have those relationships through the depository banks here in Ireland. Another question for is in relation to the capital gain tax implications. So my understanding of that is that under the Income Tax Act in India, the short-term gains are 15% and long-term gains are 10%. And under the double taxation agreement, I think what applies, the Income Tax Act provisions apply in respect of capital gains on equities. And as far as I'm aware, there's no capital gains on derivatives. So, but again, I can, if someone wants to reach out to me specifically, I can be more specific on that in terms of liaising with we have internal tax advisors as well here. So that's my understanding, is in terms of equities, the double taxation treaty follows the Income Tax Act provisions, and the double taxation treaty is more beneficial in relation to the other securities and investments. So the next email was share email. So again, I'm happy to for him to share the presentations with the email details. So I think that was it from the list of questions for him.
Yeah, just a second. If any of the participants have any questions, please raise your hand. Are there any further questions? I think there are no further questions. If anyone has any questions, please write it in the chat box.
Madam, good evening.
Yes,
Good evening.
Yeah, this is Professor Sumati, Professor of Commerce in a State University, Coimbatore, Tamil Nadu.
Okay,
Yeah,
good evening.
good evening. This program went on well, but the practical difficulty in attending this program is normally office hours beyond 6 o'clock. So why can't we carry to 7 o'clock like that? Earlier it was very much useful, the time schedule, or Saturday afternoon or evenings. Why can't we consider this request, madam?
I
That
will
is
take
one.
your feedback. I
Yeah,
will definitely take your feedback.
yeah, sure.
Yes. Yeah. So there is one question from Mr. Rohan Agarwal. Rohan, should I unmute you? Can you please speak your question? So Rohan's query is, how about renting an existing UCIT fund or sub fund, then setting up own fund?
Yes, that is also possible for them. It's possible. There are platforms, fund platforms that are operated in Ireland by some of the service providers and asset managers here in Ireland, both on the UCITS side and on the AIF side. So that specifically an asset manager can, I suppose, participate in that platform as a sub fund. So you don't have the onus then on establishing, or selecting fund management company or the service providers, because they are already there in the structure. So there's a lot of efficiencies there in that sense, where you just want to focus on your portfolio management. The downside probably of the platform is the fact that you don't have the same control as you're just a portfolio manager. So there's an element there of, I suppose, the manager balancing whether they want that level of control in their own structure, or whether they're happy to participate within a platform of a third party and just focus on portfolio management.
Yeah, I can just add to that from the Cayman side. The issues are very similar. The segregated portfolio company is typically the legal structure that's used to achieve this, so that you have a platform created typically by an administration, and they will already have an auditor on board. They will already have a board of directors appointed. So the manager just comes onto the platform, is basically given a segregated portfolio, which is completely legally separate from all of the other portfolios. And that portfolio will typically operate through a dedicated subsidiary company. And the reason for that is that when it comes to time for the manager to leave the platform, the divorce from the platform can be relatively simple, simply transferring the shares in that operating entity to the manager, so they can leave the platform fairly simply.
Thank you, Mr. Law. Are there any other questions from the participants? Yeah, so I think there are no further questions. We will share the PPTs once we have the PPTs with us. And thank you, Mr. Kellier, and thank you, Mr. Law, for taking your time out from your busy schedule and to be there with us. Thank you.
You're welcome. Thank you, Forum. And we will share the slides with you.
You're very welcome.
Yes.
Cheers. Bye-bye.
Thank you and have a good day.
Cheers. Bye-bye.
Okay, thank you. Thank you. Bye-bye.